Rule 86A of the CGST Rules 2017 enables the proper officer to block any balance lying in an e-credit ledger of the taxpayer in circumstances specified in the said rule, subject to maximum of 1 year from the date of such blocking. The effect of such blocking is that the amount of e-credit ledger which is blocked is not available for utilization towards payment of outward tax liability to the concerned taxpayer. Now the question arises when, how and to what extent this rule can be invoked, and most importantly whether this rule can be invoked even where there is no balance appearing in e-credit ledger. There may be a situation where there is not enough balance available in e-credit ledger either under one head or under all three heads. In such cases, whether the department is justified in inserting a negative balance in e-credit ledger so as to reverse the balance of ITC to be availed in further tax periods through the common portal automatically to the extent of amount blocked. This issue was examined recently by the Honorable Telangana High Court in the case of Lakshmi Kam versus Assistant Commissioner, wherein the Honorable High Court has laid down very important and interesting observations and judgment after deliberating the case in detail. In this case, the petitioner filed writ petition and contested the blocking of e-credit ledger on two grounds. Firstly, that blocking was done without issuance of any show cause notice, and secondly, such blocking could have been done only to the extent of balance appearing in e-credit ledger and not to the effect of inserting a negative balance. In its judgment, the Honorable High Court also took note of a recent judgment of the Honorable Gujarat High Court in the case of Samay Alloys India Private Limited versus State of Gujarat, wherein it was held that in cases where credit is fraudulently availed and utilized, appropriate proceedings are available to the department under the provisions of Section 73 or 74. Secondly, Rule 86A is not the rule which provides for debarring the registered person from using the facility of making payment through the e-credit ledger. In case the intention was to disallow future debits or credit in electronic credit ledger, the text of the rule would have been entirely different. The Gujarat High Court held in this case that Rule 86A empowers the department only to restrict the utilization of ITC to the extent of balance lying in the e-credit ledger and not to the credit itself. Rule 86A is not the only measure available with the department. It also has alternatives in terms of Section 73 or 74 as the case may be. Once the input tax credit is availed by the taxpayer, it forms a common pool in the e-credit ledger. Therefore, it is not justified to insert a negative balance in e-credit ledger in case there is no or insufficient balance in the e-credit ledger. Following the observations of the Gujarat High Court in the aforesaid case, the Honorable Telangana High Court held that the rule doesn't provide for insertion of negative balance in the ledger when there is no or insufficient balance lying in the e-credit ledger. There is no power invoked upon the authorities to deny the future availability of utilization of balance lying in the e-credit ledger by the taxpayer concerned. The blocking of e-credit ledger resulted in negative balance has effectively deprived the petitioner of his valuable right to discharge his liability. With these key observations and reference to the judgment in Samay Alloys, the Honorable High Court held that the blocking of e-credit ledger to the extent of creating a negative balance is therefore not justified under the law, and accordingly the court set aside the impugned order. This is a significant judgment from the Honorable Telangana High Court regarding the legal import of Rule 86A and the circumstances in which this rule can be invoked. This judgment also makes it clear that there is no power available with the authorities to create a negative balance in the e-credit ledger, thus denying the taxpayer his legitimate right to avail the ITC balance in future to set off his outward tax liability. If there is insufficient balance in the e-credit ledger and the department is of the opinion that circumstances specified in Rule 86A exist, then it is open to the department to invoke other measures like Section 73 or Section 74. Thank you very much.